Test, 1, 2, 3. Test, 1, 2, 3. Test, 1, 2. 1, 2, 3, 4, 5. 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3. 1, 2, 3, 4. 1, 2, 3.
Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention. You shall be heard. God save these United States, great state of Florida, this honorable court. Gentlemen, Supreme Court of Florida, please be seated.
Good morning. Welcome to the Florida Supreme Court. The case on the docket today is Asay versus State. McLean.
For the record, my name is Marvin McLean, and I'm here today on behalf of Asay.
I'm having trouble hearing you.
I always forget to raise that at the beginning.
You can probably raise it some more. This thing. There, like this.
How's that?
We'll see. See, now you're broken.
Where did it start?
Let's project.
I'm prepared on all the arguments in the brief, but absent direction from the court, I will start with the Brady claim on Selwyn Hall and the newly discovered evidence claim in connection with William Tobin. In this case, sort of in order to understand this case, the significance of Selwyn Hall and William Tobin's affidavits, the link in the Booker case, there was the Booker case and the McDowell case, and they're investigated separately. It's 12 days into the investigation, 11 days into the investigation, when Agent Warnement says that the 4 bullets from McDowell were fired from the same gun as the 1 bullet from Booker. Up to that point in time, there was no link between them. They had different suspects. The main suspect in the Booker case was Roland Pugh. That was based on the statement Selwyn Hall gave, the sworn statement Selwyn Hall gave, that Pugh had told him that late that Friday night he had shot a black man. And it's a sworn statement. It is ultimately sort of disregarded in light of Warneman's 100% certainty the bullets were fired by the same gun. And that becomes key to the investigation. They stop investigating Pugh, who they've arrested, and in the course of the arrest, he was shot, hospitalized, and he was still in the hospital at the time Warneman's match, 100% match came along. And they had not talked to Pugh. They had not gotten statements from Pugh at that point in time.
But so we know that now a person who does this bullet kind of analysis would not be able to say that this was a 100% match, right?
Correct. We also know that it's just scientifically unreliable evidence. It's just subjective opinion. There are no standards. There's no basis for reaching a conclusion.
Let me ask you this then. Why don't you tell us specifically why there is prejudice from this?
Absolutely, because, well, if you look at the closing argument the prosecutor gave, you will even see that the defense was trying to suggest that Asay did not shoot Booker. And the prosecutor is arguing that the clincher, we know this, because of the ballistics match. The witnesses, Bubba and Robbie, who were with Asay, they never identified Booker as the person who was arguing with Robbie. Robbie was negotiating with him.
Wasn't there some identification of him by other people who saw him running from the scene, yelling or saying he had been shot, and so don't we have some other ties other than this bullet evidence that would lead us to conclude that Mr. Asay shot Mr. Booker?
There were 4 witnesses, 2 of whom testified, seeing Booker. Well, one of them identified Booker as the person. The other individuals just said that they saw this black man come down Laura Street from 6th, running by, saying somebody had shot him. The time frames, Thomas, who does not testify, says it's between 11 and 12. Knight, who does not testify, says it's between 12 and 2. Pace and Patterson, who both testify, say it's after 2. And the time frame becomes important because initially the police saw no reason from what those 4 witnesses saw that it was not Pugh. Pugh was not eliminated on the basis of those 4 witnesses. Those 4 witnesses did not see the shooting. All they said they saw was a black man who one of them identified as Booker running down the street saying he had been shot and running underneath the house a couple of doors down.
Well, on this claim, the judge didn't give a evidentiary hearing and did the judge find it was procedurally barred?
Well, there was no evidentiary hearing.
But could you address why this is not procedurally barred? And other than that he didn't have you as his lawyer for this period of time, the issue of unreliability of this is not CBLA evidence. It's the looking at 2 bullets and comparing the marks on them?
Correct.
Okay. That's not, I mean, that's been, as far as whether it's actually reliable or not, has been under consideration for years. And what you have now is you say, well, I found an expert that will say that it's not reliable. I'm trying to understand how it's not procedurally barred.
From 2005 until 2016, Mr. Asay did not have counsel.
Well, he had counsel in his federal appeal.
And even right now as we speak, the state is trying to stop the Chew from representing, who's federally appointed in a case, from representing him in state court. The federal counsel cannot come into state court.
But they could have raised the claim why couldn't they have raised it in federal court?
It's not a claim in federal court.
But
It's not a constitutional claim, and it hasn't been presented to the state court.
it's my understanding that that a federal attorney could, in fact, come into state court and ask to be appointed to represent the defendant. That's not true?
The federal attorney, and I've been appointed federally, and I have come into state court and asked to be appointed. The federal attorneys appointed to Mr. Asay's case did not do that. Okay. And there are big issues regarding Mary Catherine Bonner, who the federal judge found should be disbarred, in essence, when ruling on her decision not to file the federal habeas on time without telling her client.
Well, I can understand that might be a problem in another case, but in this case, the attorneys could have at least attempted to do that, and why they did or did not, that is really not.
Well, I'm not sure that necessarily all attorneys should be held to my standard, but the fact that I've done it in some cases, I don't know that that's necessarily the standard to judge Mary Catherine Bonner and Thomas Fallis, who were appointed in federal court. Well, first of all, Mary Catherine Bonner kept the files and records in a place where they ultimately were unusable, and Tom Fallis ultimately destroyed the few boxes he got. In order to be able to investigate this issue, which developed in 2008, 2009 is when the reports came along indicating there was a problem with this, and I just want to make the point quickly, there was no gun. So the ballistics match is just between 2 bullets. And it's specifically that type of evidence that these reports in 2008, 2009 came out and indicated was unreliable.
But you know that the reports themselves, we've said, would not be newly discovered
Correct.
evidence.
Correct.
So you would claim that if, based on seeing those reports, you would have gotten an expert. So in other words, what's the newly discovered evidence that you're claiming, and which would require you to prove a probability of an acquittal?
Well, the newly discovered evidence is once counsel is in place. Mr. Asay is on death row. He does not have the ability to even know about the reports, let alone investigate them. He has to have counsel in place, and so the clock should not start running until counsel is appointed. Alternatively, the other important aspect here is that the Brady claim itself causes the need to investigate Agent Warneman's testimony. The Brady claim is premised upon a statement that was not disclosed until January 27th of 2016. There had been public records disclosed previously, but handwritten notes were not turned over. And I don't know, I don't understand why the file on Roland Pugh, which contains handwritten notes, includes Selwyn Hall's sworn statement and other handwritten notes about the Pugh arrest on July 23rd of 1987. I don't know why those weren't turned over, but they clearly were not turned over before. There were handwritten notes that were given to the judge for an in-camera inspection. Those are under seal. I don't have access to them. They may have been there.
One other question. Why is it important that the two murders be linked? The death warrant is for, he received 2 death sentences. Would you agree that there might be stronger evidence as to his having shot and killed either McDowell is the first, is that the second one?
Undoubtedly, there's stronger evidence as to McDowell.
Okay, so, but why would that be, what would be wrong with that analysis?
Well, the state used the testimony of Thomas Gross, who had recanted before, and this court said you have to accept that recantation as true, that he claimed that Asay confessed to both shootings using racial epithets and saying it was due to racial animus. And the prosecutor specifically argued the fact that Booker had been shot first created the premeditation that he was going around looking for people to shoot, to argue the second one was premeditated. One of the witnesses, Charlie Moore, who testified that Asay had, and this is the person that linked Asay to the McDowell homicide in the first place, indicated that Asay had said he shot McDowell because he kissed him and realized it was not a woman, it was a man. So, and in addition, there was a lot of alcohol use. So there was a way to argue second-degree murder as to McDowell. It goes to, and as to McDowell, they use Booker as an aggravating circumstance. So the two cases become linked in that fashion, using Booker to push for premeditation as to McDowell, also CCP as to McDowell, despite Moore's testimony that the state presented that it was in reaction to kissing this person and realizing it was not a woman, it was a man. So
you're getting close to your rebuttal time, and I was just wondering if you had anything new that you would like to add. I know you've been here before arguing the Hurst line of cases, and so do you have anything new that you'd like to add on that issue?
Well, what I would say is, well, first, pretty much it's the same argument as to retroactivity. I don't know that I have anything new to add to that. But in this instance, I would also be arguing life sentence is the solution if the error is found. But alternatively, to the extent that the court may reject that, assuming arguendo, and you're looking at harmless error, I don't think you can do the harmless error analysis in this case until there's been an evidentiary hearing on the Brady and the newly discovered evidence because of the link between the two cases, because the aggravating circumstance, there's only 2 aggravating circumstances as to Booker.
But it was both of those aggravating circumstances as to Booker are things that have been found by the jury. You have a prior violent felony, which was the contemporaneous felony, and you have, he was under sentences of imprisonment based on a grand theft auto, I believe it was, in another state, correct?
Grand theft auto in Texas, he was on parole. First, as to being on parole as an aggravating circumstance, my argument is the statute says sufficient aggravating circumstances, not just an aggravating circumstance. Second, the reason for the language sufficient aggravating circumstances was to comply with Furman and to ensure that a proper narrowing is occurring. Just simply being on parole by itself would not satisfy Furman.
Yeah, but you have on parole and contemporaneous felony.
Correct. Yeah, there's also the contemporaneous felony. Again, that's according to the statute, not automatic, because there has to be a finding by the jury it's sufficient. And in this instance, you also...
So you're not arguing that the fact that a jury found both of those aggravators, you're saying you've got to take it a step further, and the jury also has to say that there's no mitigation that outweighs these two aggravators?
Well, let me just back up.
Sufficient mitigation.
Right, well, it's sufficient aggravators. I mean, the steps are, first of all, the jury never found an aggravator in the case. The jury is just instructed, and they return a 9-3 death recommendation. So there's no finding of an aggravator by a jury. The state has argued...
So if the jury, let's look at this. If a jury is presented with, even in this case, for example, a prior violent felony, and say there is not one, when in fact he had just been convicted of another violent felony, how do we handle that?
I submit it under the statute, the way it's written. It says what has to be found. There are two factual findings that have to be found by the judge to impose death. One, sufficient aggravating circumstances exist. So there's no automatic one ag and you're qualified. There's a requirement in the statute that there be sufficient aggravating circumstances and that it has to be found as a matter of fact. That did not happen.
Well, you're making the leap that sufficiency, this is where is the factual finding. I'm with you on aggravating circumstances are facts, unless they've already been found, as Justice Quinn said. But I think where we're going to get in a discussion of what Hurst means is the weighing process, which is what sufficiency has to go to. Is that a fact, or is that a blended judgment call as to the weighing process?
Well,
it's not a fact. It's not to say sufficiency is a fact.
I submit it is a fact. When it comes to the statute first of all, the statute never says one aggravator and you're eligible. The legislature's inserting that language. That indicates it wasn't there before. That's not the law in this case. It wasn't there. One ag and you're eligible is not the law in Florida. The statute says there has to be a finding of sufficiency, and it describes it as a factual finding. As a matter of fact, the judge has to find the aggravators are sufficient. No reference to mitigation at that point.
But you understand that you can't, the sufficiency has to be looked at with mitigation.
No, it does not. Under Furman, sufficiency is whether or not he's among the worst of the worst. Whether or not you have properly narrowed who's eligible for death. It has nothing to do with mitigation. Under Furman, you've got aggravation, which makes you eligible or authorizes a death sentence, and it's the narrowing. And the mitigation is the reasons why to come back from that. So the sufficient aggravating circumstance language is an effort to satisfy Furman. That's when it's adopted. It's adopted at the end of 72. It goes into effect in 73. It's in order to comply with Furman. In fact, in Profit v. Florida, the U.S. Supreme Court specifically quotes that language, sufficient aggravating circumstances. And in the years since 1973, we've gone from 8 aggravators to 15. And in doing so, one aggravator, some of these aggravators just don't narrow. The narrowing that is required by Furman is dependent upon that word, sufficient aggravating circumstances. That's what makes Florida different from Arizona and other states, because we have the word sufficient, and it's described in the statute as a factual finding that the judge has to make.
You're way down into your rebuttal, but I'll give you
reserve
some
the rest
extra
of my
time on rebuttal,
Thank you.
given the issues.
May it please the Court, Assistant Attorney General Charmaine Millsaps representing the state.
You could keep your voice up also.
Okay, yes. I actually do better if I just yell. Okay, I'm going to talk about Brady, and then I'm going to talk about Hurst. Okay, first of all, under Brady, I want to get a fact straight. Gross never recanted in this case. As this court acknowledged in the post-conviction appeal, Asay versus State at page 982, he was going to be presented at the evidentiary hearing, but he was never called. So there is no recantation for Gross before this court. They had him outside, but refused to present him and refused to show the affidavit. So It is not accurate to say gross. So everything having to do with gross recantation, just forget. There is no recantation before this court. Secondly, ballistics evidence is still scientifically reliable and is still admissible. So on the newly discovered evidence claim, that testimony, not at 100%, but at testimony that the FDLE firearm ballistics expert would testify, in my opinion, the bullet from the first victim, Booker, matched within a reasonable degree of certainty, matched the bullets from the four bullets from the second victim, McDowell. So you would still even have that testimony, just not at that same level, okay? And what's more, what this claim really boils down to is that we didn't prove the first victim was Booker. I want you to understand everything that happened to the first victim happened on the same street, just a few blocks away. First, Asay's brother and a friend of his brother, Bubba, testified that he shot a black male. No, they could not identify Booker. A couple of blocks away, Mr. Patterson, who was in his car, was in an accident. He wasn't actually in the car. And so he was just fortuitously on the street because he had had a fender bender. Mr. Pace had hit him. He testifies repeatedly, it was just a little thing. So they're not really upset. And Booker, the victim, runs by him, he knows.
Do we know the time frame, the time period between the time that the person was shot, when Mr. Booker was seen, and how far apart?
It's a few blocks on Laurel Street. And now, Your Honor, they're not exactly, it's between 2 and 2:30 in the morning. That's what everybody says. We do not find the victim's body until 7 hours later, a block or two away, but still on Laurel Street. All this happens at 2 o'clock in the morning downtown in Jacksonville. He's shot, he runs past Patterson, who knows him, and then we find him a block away, 7 hours later, his body with and he's running holding his side. The victim's running holding his side, and the medical examiner testifies that that the bullet wound is in fact through his abdomen. So we find a body with exactly the kind of bullet that they say. And when somebody runs past you, it's not like a normal encounter. He's literally running past him saying, "I've been shot." That's a dramatic thing he's going to recognize. We have acquaintance testimony that the victim was in fact Booker. So there's no possibility of an acquittal on retrial, which is the standard for newly discovered evidence. Okay, and I also think counsel is tangling Brady and newly discovered, and they're two different claims. So I've already discussed the newly discovered. The Brady has to do with a statement.
So you're not going on you're not arguing this based on procedurally barred?
I think it is procedurally barred because this way. This is only really properly, it's clear defense counsel had this stuff. This is only properly raised as an ineffective assistance of trial counsel claim, okay? Because counsel had this, trial counsel had the question about whether this type of bullet analysis was deficient? No, the bullet goes to the newly discovered. The Brady is about Seton Hall and whether Pugh was a suspect. Really, Hall and Yankee really go to, that's exactly what I want to get straight, okay? One has to do with whether Roland Pugh, the Brady claim, was an early suspect and whether defense counsel knew that. That's the Brady claim. Over here is the ballistics. That's the newly discovered evidence claim. We have no business. They should not have been raised as one claim.
Well, on that one, on the Brady issue, there's Mr. McLean, although he argues in his brief that the hearing where this was all going to be discussed was like set within an hour, and he had no chance to be at the hearing, where whatever the judge received, the emails that explained that this had been produced was discussed. I guess my question on this is, why isn't it better that there be an evidentiary hearing so that we have out in the open that the counsel had this information as to the Brady claim, and that on the comparative bullet, the bullet mark evidence, that the question of that he did not have a state lawyer for the 10 years is actually fleshed out. I mean, because this does seem like an unusual set of circumstances with a lawyer not having no state lawyer for 10 years. So why isn't it better to go back for an evidentiary hearing?
Okay, and I will answer that, but I want to, the hearing that the judge held was on my motion to prohibit the proffer. It was not any of this. Mr. McLean never filed a motion down below telling the trial court he didn't think that she should be relying on this evidence. So that hearing was on my motion to preclude a proffer. And incidentally, the only thing that came out at the end of that hearing was that the records were sealed. So there's no harm to his not being there. And I don't think it's fair to call a hearing ex parte because you refuse to attend. I don't think you can do
the
that.
timing of this refusal, I mean, we're talking about an hour. I realize we're under these tight time frames, and I'm not faulting anybody on this. I know that we are, we put these strict time frames in, but it didn't appear, as at least as I looked at the record, that this was a refusal to attend. It was, he got notice as the hearing was occurring.
I think you should attend the hearing rather than go to the bank, Your Honor. And you can get your co-counsel to sit in for you. There are two co-counsel in this case. It's designed to stop the judge from really hearing my motion. I'm just trying to get straight with you, Your Honor, that really that hearing was not about the Brady. Nobody ever said to the judge that it was improper to rely on the public records disclosures. So that was never said to this judge. That is being made for the first time up on appeal. Okay, so the judge never had that. But regarding I don't think an evidentiary hearing is necessary. It's not just to flesh out stuff. If the record conclusive rebuts stuff, we do not hold evidentiary hearings. I think that as a matter of law, you can deny the newly discovered evidence claim. It's very clear that's not going to, having the expert just move the degree of his testimony down is not going to produce an acquittal on retrial, especially in light of Patterson and the fact that this all occurs on the same street. And regarding the Brady claim, all we're going to do at any evidentiary hearing is I'm going to stand up and introduce these two documents, and then we're done. Well, the documents are already part of the record. In other words, the reason we don't need an evidentiary hearing is there's no real point to an evidentiary hearing. Okay, both the documents that he's talking about, the depot and the statement from Hall, what they got was not the handwritten notes, but they got the continuation report, the homicide report. And that, it is often, we do that all the time. The handwritten notes are turned in to a typed report, and we disclose the typed report, okay? So understand the substance of what's in the handwritten notes was typed and given to defense counsel. So the only way this can properly be raised is a claim of ineffective.
Is there any differences between what was in the handwritten notes and what was in the typed information that you say was in fact given to defense counsel?
Some minor details. Let me give you an example. In the typed notes, the account is that Pugh shoots somebody in his yard. In the handwritten notes, the exact address is given. It's that kind of stuff. No, that Pugh shot somebody, a black male, that night on outside his house is the same. It's minor little. I would say the handwritten notes have some.
Live? And where does Pugh live? Do we know in relationship to where these crimes took place?
The 1400 block of North Market Street. But this occurs more on Laurel Street. Yes, Market Street's downtown Jacksonville too. But it is not the exact same street. And the victim, the first victim, Booker, was shot Laurel and 5th or Laurel and 6th, and then Patterson sees him a couple of blocks, and then 1 block later is where we find his body. It's 7 hours later after that. But the first 2 incidents, the shooting and Mr. Patterson see him, happened at 2:30, and then 7 hours later in the morning, a patrol officer finds the body underneath the house. So, but the Roland Pugh, and remember this is a Brady claim, so it doesn't even matter what's in it. It matters that we disclosed it. We disclosed this. Defense counsel knew that Roland Pugh was a suspect based on the shooting. He got that information based on Roland Pugh's own statements to other people, both Yankee and Hall, that he had shot somebody at Market Street instead of Laurel. That same, it sounds like it was even later, like 4 o'clock or something, but that same night, that Friday night, I think it was, that he had shot somebody as well. Defense counsel knew this. So yes, this is only properly raised as a claim of ineffectiveness of trial counsel for not presenting Pugh as an alternative suspect. It's clear that he knew about it. He made that choice. And so yes, that's procedurally barred. There's no reason we should be doing that. That should have been explored at the first evidentiary hearing. There was an evidentiary hearing in the first post-conviction. There's no reason for them to, just because he gets a new lawyer who thinks that should have been the claim, a claim of ineffective assistance of trial counsel for not presenting Pugh, just because you get a new lawyer, you do not get a second evidentiary hearing. Regarding Hurst, the state in its brief makes 4 main arguments: non-retroactive, that there's a prior violent felony, that there's a contemporaneous felony, and that it's harmless. I would like to, before we get to retroactivity is the big argument, but before we get there, I'd like to talk about what I think Hurst actually said. Here's what counsel is saying: any fact in a statute must be found by a jury. That's not Apprendi, that's not Hurst, that's not Ring. The fact must increase in Apprendi's words or aggravate in Allende's words before the jury has to find it. That's when a fact becomes an element that the state must prove beyond a reasonable doubt, when that fact increases the penalty. Take our criminal punishment code. There are whole bunches of facts in our criminal punishment code. They're all found by the judge. Why? Because none of them increase the penalty. You have a statutory, and none of them create a minimum mandatory like Allende. If a fact is just a fact that does not increase the penalty or aggravate it, then the judge, we still have sentencing factors in the wake of Apprendi and Ring. It must go up, and mitigators go down. So mitigators are never found.
Obviously, I agreed for many years because I kept on saying that it was just a prior violent felony that had to be found. But here's the difference. When you look at Apprendi or any of these cases that say if you have a gun, then it goes from, the punishment increases. The death sentence is not like that. It's, if you don't have aggravating circumstances, it is a life sentence. But it's not that if you have aggravating circumstances, then it's a death sentence.
Yes, it is like that constitutionally. Let's not confuse what the Sixth Amendment requires. We're here on what the Sixth Amendment requires a fact to be turned into an element. When a fact increases the penalty, it becomes an element. Constitutionally, yes, all you have to have is one aggravator. Then do we have to follow our statute once we meet the constitutional requirements? Of course. Okay, so I'm not saying that. We're going to have to follow our statute, but we're here on what the Sixth Amendment requires, what's constitutionally required. It is a finding of one aggravator that is constitutionally required.
But where is that in as Mr. McLean said, we're not dealing with the Arizona statute. We're dealing with the Florida statute, which was passed right after Furman, and it doesn't say one aggravating circumstance has to be found. It says sufficient aggravating circumstances. So in a world that doesn't have a statute like Florida had, maybe that's the case. But
no, that's not what the United States Supreme Court
we don't.
said. I'm
again,
quoting from Tupelo versus California. To render a defendant eligible for the death penalty, the trier of fact must convict the defendant of murder and find one aggravating circumstance or its equivalent at either the guilt or the penalty phase.
I'm sorry, what case is that from?
That is Tupelo versus California. I'm going to spell it because my pronunciation is so bad. Tuilaedpa. And that's from 1994. Understand, Your Honor, let's not tangle two things. First, it's what the Sixth Amendment requires, and then, of course, we follow our statute, okay? But the Sixth Amendment requires only facts, and they overruled Spaziano, the Hurst court overruled Spaziano and Hildwin based on Apprendi. So what Apprendi says matters, and Apprendi says only facts that increase the penalty are what have to be found by the jury. And then the United States Supreme Court has made it very clear in several cases, they cite cases in that case I just cited to you, that it's that one aggravator that increases the penalty to death.
But,
So,
it seems to me that when we look at Hurst, I don't interpret Hurst as saying that once you find one aggravator, it's over. It seems to me that Hurst talks in terms of sufficient also. So how do we get to, I don't know what California statute provides for or many of these other states, but I do know that our statute does not have anything that says once one aggravator is found, you are now eligible for the death sentence. So how do we make that leap to get to that under Florida law?
Hurst at both two places toward the end says, the decisions are overruled, Spaziano and Hildwin, to the extent they allow a sentencing judge to find an aggravating circumstance. And then at the end, it says Florida's sentencing scheme, which requires the judge alone to find the existence of an aggravating circumstance, is therefore unconstitutional. Your Honor, what I'm trying to say is this. There's what the Constitution requires, and then there's what the statute requires. We're not up here arguing that you should ignore the statute. For example, one of the new death penalty statutes, at least the ones I've seen, are going to say that all the aggravators have to be found by the jury. But we're up here deciding what Hurst and the Sixth Amendment require. What does the Constitution require? So first you determine what the Constitution requires, then of course you follow the statute. But the Constitution only requires that one aggravator. And secondly, Your Honor...
So what part of the statute are you talking about? In Hurst, at least a part of the statute was declared unconstitutional. So what are we following now?
Well, I'm following Hurst, and incidentally, sufficient is an adjective.
No, you said once you have the aggravator, of course we now follow the statute. What part of the statute are you referring to that we are now following? Because it seems to me that that part of it has been declared unconstitutional, correct, in Hurst. So what part are we now following?
What Hurst requires is the finding by a jury, a specific finding. That was part of their problem, that it wasn't specific. A specific finding from the jury of an aggravator, and then, that's what Hurst requires, okay? And then all the other things, the judge can decide. So you follow the statute. It's just a matter of who gets to do the rest of it.
So
the weighing, the finding of mitigation, the judge can do.
So you're saying that once we're in the penalty phase, once the jury finds any one aggravating circumstance, the trial judge is then free to find any other aggravating circumstances.
Yes, and more importantly, yes, that is exactly what I'm saying. Constitutionally. Now, we're going to have a new statute, and it's going to require that the jury make those findings. Well,
all of the aggravating circumstances.
What?
A finding on all of the aggravating circumstances?
That's how I understand that. Now, it hasn't been passed yet. But what I'm saying is, first you meet the Constitution, and then you do what the statute says. But, Your Honor, under our current statute, Hurst, we need a specific jury finding that is binding. That's the Hurst problem, the Hurst Court's 2 problem, that it wasn't specific enough and it wasn't binding. That finding, for example, of non-aggravation needs to be binding. In other words, no overrides. That's part. Hurst is saying two things. We want it specific, not implied. We want to know which aggravated the jury found. And then we want that finding, for example, of non-aggravation to be binding. They didn't like that's the two parts of the Constitution of our statute, the override provision and the not specific that the Hurst court said, no, we're not doing that. Okay, that's the part that's unconstitutional.
So who weighs the aggravators in your scenario?
Constitutionally, the jury must find one aggravator. That one aggravator is an element.
The mitigators.
Mitigators may be, because they decrease. It is so important. Allende and Apprendi talk about increases in aggravation. If you go down, which is what mitigators do, they decrease the penalty. They are not elements. They cannot be elements. The state doesn't prove mitigators. The defense proves them, and not at BRD. Look, when you read a statute, there are whole bunches of facts in a statute. When you read a statute, you're trying to pull out the facts that increase the penalty, because those are the facts the jury must find. Every other fact, for example, in our criminal punishment code, can be found by the judge alone. So it's only facts that increase the penalty. And Apprendi is all through this, as is all through the Hurst opinion, as is Allende.
All right, thank you. Your time is up.
Thank you for your time. We ask that the trial court's summary denial be affirmed. Thank you.
Okay. Give you the additional time that she received, another 2 minutes and 25 seconds.
Thank you. I submit the state's just misreading Hurst. Hurst, Apprendi, all of them say you look to the statute. The Sixth Amendment right attaches to the facts required by the statute.
So what's left in the statute now?
Nothing. I mean, the statute provides that there has to be a finding of sufficient aggravating circumstances. That's the fact. Then it says the second fact is that there are insufficient mitigating circumstances to outweigh the aggravation. Those are the two facts.
So tell me specifically, is your argument that a jury must find each and every aggravator, the jury must find each and every mitigator, and then the jury must weigh those and make a determination of life or death? Is that your argument?
My argument is Hurst says each fact necessary for the imposition of death must be found by the jury. It's right at the beginning of the opinion. That's what it says. And you look to the statute, what the facts are. The statute does have the list of the aggravators. It has statutory mitigators, it doesn't have the non-statutory mitigators, but it says that there has to be a finding of sufficient aggravating circumstances. I presume in order to get to sufficient aggravating circumstances, you have to first identify the aggravating circumstances.
So you have to find them all.
Well, you have to find whatever you're going to find. Whichever aggravators you're going to find have to be found, and then there has to be a factual determination that they are sufficient, as the jury instruction says, sufficient to justify the imposition of a death sentence. That's the fact.
So, okay, so I just want to make sure I understand your argument. So you're saying that sufficiency is also a fact?
Yes. And that's what Hurst says.
Let's go back to, I
Well,
guess.
are you going to finish the question, though? She said, how about the mitigators? You stopped with the aggravators.
Well, it's in the statute that there has to be insufficient mitigators to outweigh the aggravation.
So the jury has to find that as well.
I submit that the reading of Hurst, that every fact necessary to the imposition of death has to be found, that's a fact.
So the answer to my question was yes.
Yes, Your Honor.
Okay.
I'm sorry.
And then is the answer to Justice Quentz's question, not my question, but that before death can be imposed, there has to be a third finding, and that is that the mitigation does not outweigh the aggravation. That's the third thing that she asked.
Well, there's this confusion about whether the mitigation outweighs the aggravation or the aggravation outweighs the mitigation. The statutory language is insufficient mitigators to outweigh the aggravation.
Fine, whatever that third.
And so that is a fact in the statute, and since Hurst says those facts have to be found by the jury.
So your answer response is yes to each three of those.
Yes, Your Honor.
That's
So
fine.
the jury would have to consider all mitigators, would have to be presented to the jury.
The jury would have to return a finding
Right.
that the mitigation does not outweigh the aggravation.
But
in order to get there, they have to consider the
But the
mitigation.
time to present the mitigators would be in the presence of the jury.
Yes, Your Honor.
So you're not going to have the situation where defense counsels basically, out of strategy, decide, I'm going to hold back on this mitigator because it doesn't look good in front of the jury, and I'll present it later on to the judge.
It absolutely changes the strategy, because just as you do a guilt phase, many defense attorneys do a guilt phase on the notion of getting one juror as a holdout. And if you're facing not a 7-5 situation, a majority vote, but a unanimous verdict, it changes how you would approach it. And absolutely, I think that it would change the strategy exactly that you're talking about, that you wouldn't hold back for the judge because you want to go for the one juror who would find in your favor, instead of banking on going to the one judge and hoping he would find in your favor. So it changes the strategy completely, which is one of the reasons why I've also alternatively argued that there should be an evidentiary hearing like after Hitchcock in Meeks v. Duggar on how this change affects the strategy, how you would approach the trial differently. You would do voir dire differently. You would exercise peremptory challenges differently. You would have the jury instructed as to the importance of their verdict, that it's not advisory, that it's binding. Everything would be different.
Well, let me ask one final question on the retroactivity of Hurst. You would agree that Mr. Asay's conviction was final prior to Ring?
Yes.
It was also final prior to Apprendi?
Yes.
And so what is so why would, and you would also agree that the United States Supreme Court has said that Ring does not apply retroactively?
They said that as to Ring.
Yeah,
I submit that this is broader than Ring. And we also now have Montgomery v. Louisiana, which has changed T. And we don't really know how that's going to play out in the future with the U.S. Supreme Court. State of Florida doesn't follow T, it follows Witt. And one of the important factors under Witt is looking at the fact that Paul Beasley Johnson, his conviction was final before Mr. Asay back in the early 80s. He's getting the benefit of Hurst. Ricky Roberts, final before Mr. Asay. He's getting the benefit of Hurst. Paul Hildwin gets the benefit of Hurst. So that the arbitrariness associated with just it turns on when the U.S. Supreme Court handed down the decision, and some people are getting it from way back then and some people aren't. Under Witt, that calls for uniformity and fairness, and it calls for retroactive application to everybody, just like Hitchcock.
Thank you.
Thank you.
Thank you for your arguments. Court's in recess.
All right.